Hello.
How are you doing?
I'm very well, thank you. How are you?
Okay, okay.
Thank you for joining us and for participating in this. Um, and welcome
My,
to the
my pleasure.
Parental Alienation Omnibus. Please introduce yourself and tell us what you do and where you are from.
Okay, I was born in England, got my law degree there, qualified as a lawyer in England, moved to Israel in 1978 with my wife and three small children. We've had four more children here. Now we've got a whole troop of grandchildren, all of them in Israel. I requalified as a lawyer here in Israel. And when they set up the Unified Specialist Family Court in 1995, I was appointed a judge of that court, and I sat in the family court in Jerusalem until I took early retirement in 2012. Since then, I've been researching, writing, lecturing here and in many places around the world on family law, particularly as it relates to children. And in the last 3 or 4 years, I've been concentrating on two areas. One is what's called parental alienation. The other is reform of family courts. And I'm now giving courses and consultations to various governments and NGOs around the world on those topics. So that's what I'm doing now. My most recent thing for a European country, I'm running a course for senior officials to familiarize themselves with what's called parental alienation and also to find resolutions. My articles recently on the topic deal with prevention, primary prevention in the sense of raising public awareness to the existence of parental alienation and the damage it does. And that's why organizations like yours are so important. The second stage is educating those professionals who come into contact day by day with children. And we're talking particularly about teachers, pediatricians, family doctors, social workers, psychologists, in order that they can pick up the early signs of problems of contact between the child and a parent, and also they can spot parental behaviors which might lead to a breakdown of contact. That's the second stage, and I lecture to groups of these professionals. And the third stage is to make sure that if the case cannot be diverted to therapeutic means and it gets to the court, then the court has to have the appropriate powers, it has to have qualified judges who are specialists in the field, it has to have social services available, and then these cases have to be dealt with very, very swiftly, because the longer a child is not in contact with a parent, the more difficult it is to re-establish contact. And if it goes on, as it does in many countries, for months and years, then the situation becomes very, very acute and cannot be remedied. So those are the projects that I've been working on.
Fantastic. I'm so happy that you're actively involved in educating professional people who deal with this because that's a big need in South Africa, where I am as well. Parental alienation is not widely regarded as an accepted phenomenon yet. There's still a lot of work to be done to get the legislation where it needs to be. Um, so that's great to hear. In your country, is parental alienation accepted as a term, is it properly defined, and can it be diagnosed as such?
Well, I'm not a medical or mental health person to talk about diagnosis,
Mhm.
but the phenomenon is recognized. It's recognized by the courts. It's recognized by the professionals who deal with these things. So far as experts are concerned, there are experts. There's no such thing as a formal expertise in parental alienation.
Mhm.
The term itself, as you know, is somewhat controversial.
Yes.
And so we are continuously explaining what we mean by the term. What we mean by the term is where one parent, for no reason connected with the welfare of the child, uh, brings about a situation that the child is not in contact with the other parent.
Mm.
And there's also another situation where the child, for his or her own reasons, decides that it's better to have no contact with one parent, and the other parent in that case, if that parent fails to persuade the child that he or she should be having contact with the other parent, that is also tantamount to action by the parent. We define it as child psychological maltreatment. We define it in terms of contact failure. We don't, and of course, there are some cases in which a child refuses to have contact with a parent for very good reasons. If that parent has been abusive to the child, to a family member, and it's impossible to protect the child from that parent, even by supervised contact, then it may be justifiable for the child not to be in contact with the parent.
Yes, of course.
Those are, however, extremely rare cases, and the presumption has to be that a child needs contact with both parents, needs the love of both parents, and needs to know that even though mom and dad are separated or divorced, they still love him and they still want contact with the other side's parent.
Yes.
So that's the thrust of what we're doing. But as I say, it's recognized here. A year and a half ago, a pilot program was set up whereby in one of our family courts, all cases where parental alienation was alleged were referred to a specific judge who is experienced in the field. And he was able to weed out on an initial basis the real allegations and those which were not firmly based, and he took charge of the case. This is where judicial management of these cases is highly important, and that led to a practice direction by the president of our Supreme Court in October last year, whereby in any case where abuse in family court, where abuse is alleged, that could be physical abuse, it could be sexual abuse, it could be psychological abuse, it could be interference with contact. There has to be a hearing before a judge within 14 days of filing. Both parents have to show up with their lawyers, and the judge will then hear the initial claims and may at that stage immediately make an order for contact where contact is not taking place, and for therapy for the child, and for re-education of the parents. And that judge will continue to have the case. He'll make orders that the parties have to report within 14 days, and then he'll have a hearing immediately after the time for report. Where it's necessary, he'll appoint a guardian ad litem for the child. That's a lawyer who will represent the child's interests. Where necessary, as I say, he will give orders for therapy. If necessary, he'll make orders for supervised contact where he thinks that's necessary. And so we don't have the situation here where it's dealt with like any civil case, where you file a statement of claim, the other side has 45 days to file a defense, and then they ask for more time because they've got a runny nose or the lawyer's busy. And then you have a pre-trial hearing 3 or 4 months down the line. And then there's a lot of stuff about appointing experts. So you only have a trial a year down the line. And in that time, the child is not in contact with the parent. That is the case in many countries where we would have expected a higher standard of work. I know there are judges in South Africa who do understand the situation. I'm not sure if all of them do, but as you quite rightly said, education is essential. And I have to tell you that the Israeli court system also is very assiduous, very keen that people should actually obey the orders. It's all very well making an order, but if they don't obey the order, then you're making the whole thing into a laughing stock. So that the courts here have developed a series of sanctions against a recalcitrant parent who is not complying with orders. Those can include financial remedies, including a fine, or paying law costs to the other party, or paying costs to the state exchequer. That may involve reducing child maintenance, but it may also involve much stiffer sanctions including, in an extreme case, removing the child from both parents or removing the child to the other alienated parent. But also under our contempt of court ordinance, it's possible to commit to prison a party who is in contempt of court because they're not complying with the court's order. I had a case in which, in this case, it was a mother who was not allowing or not compliant with an order that the father should see the child. And after many excuses and delays, I told her, look, madam, little Johnny is going to be with daddy on Sunday. And if he isn't, you show up in my courtroom on Monday with your toothbrush, because I'm going to send you to prison for 3 days.
Yes. Wow.
For contempt of court. But of course, in that time, little Johnny is going to be with daddy anyway. What would you prefer? And she preferred to be compliant with the order. How do I know? Because several years later, a gentleman came up to me at a wedding and said, Judge Marcus. I said, yes. He said, do you remember me? I said, well, really not, because I dealt with a lot of people. And he gave me his name and he said, I'm still seeing my kid. And this was 8 or 9 years later. That was great. But that requires, of course, a judge who is experienced, a judge who is knowledgeable. It requires social services who are attached to the court, who can give the judge the necessary information and advise the clients. And in the Israeli system, we have that.
I think it's fantastic. We've still got a long way to go in South Africa, but it's wonderful that there's proper legislation and that it's actually in the hands of the judge from the start, and also there's recourse for the people who are being alienated, and the people don't just get away with it. In many places, the alienators literally just get away with what they've done.
You shouldn't think that everything is perfect in Israel. There are still alienated kids and still alienating parents and alienated parents, but at least the cases are dealt with promptly by the courts. The difficulty is, of course, that in some cases, the cases get to court too late. And that may well be because the alienated parent really doesn't realize what's happening. Because the parent, him or herself, does not know what's really going on.
Yes.
And that's why the emphasis has to be on prevention, as I say, by increasing public awareness. And I have to say, in those cases where the court ordered sanctions, the press got hold of this. And so the effective and definitive actions of the court are quite important in increasing public awareness of the situation and how seriously the courts take it.
Yeah.
But you mentioned legislation. There are many ways in which a court, which is properly apprised of the situation, can use the existing powers and does not need legislation. I'm pretty sure that practically all countries have a contempt of court legislation or contempt of court processes, which do not require new legislation. It's possible for a court system, provided the president of the court or the president of the higher court is aware of the situation, to designate judges and to put on foot education courses, training for those judges to make them more aware of family situations. That can be done without legislation.
That's true.
It's also possible to divert cases to a family law specialist judge. And it's also possible to persuade the social services to collaborate with the courts in these cases more widely and to have joint trainings. And these are the things that I'm advocating for and I'm planning in a number of different countries.
Very true. I'd love to chat with you some more. Maybe we can look at doing some more interviews. Thank you so much.
That would be fine. And it's a great pleasure. And congratulations on your initiative.
Thank you so much. We'll speak soon.
Be well.
Take care.
Bye-bye.
Bye-bye.